This is the Mueller Report audio, presented by Government Unfiltered. I'm Dan Williams. This version of the Mueller Report contains updates released by the Department of Justice in June and November 2020, following lawsuits by BuzzFeed News and the Electronic Privacy Information Center. Due to these new releases and through the support of your donations, I'm re-releasing the Mueller Report audio to replace the previous versions and compiling the subsections into their larger sections. The previous episodes will be archived and available at MuellerReportAudio.com. To keep these episodes commercial-free and free for everyone to access, this podcast operates on the value-for-value model. I produce the audio, and you decide what it's worth. You can donate at MuellerReportAudio.com, or, as I continue to read public documents and make them available here in audio format, you can support with a recurring monthly donation at patreon.com/TimberlaneMedia. Section 1. Background Legal and Evidentiary Principles. A. Legal Framework of Obstruction of Justice. The May 17, 2017 appointment order and the Special Counsel regulations provide this office with jurisdiction to investigate federal crimes committed in the course of, and with intent to interfere with, the Special Counsel's investigation, such as perjury, obstruction of justice, destruction of evidence, and intimidation of witnesses. Because of that description of our jurisdiction, we sought evidence for our obstruction of justice investigation with the elements of obstruction offenses in mind. Our evidentiary analysis is similarly focused on the elements of such offenses, although we do not draw conclusions on the ultimate questions that govern a prosecutorial decision under the principles of federal prosecution. Here, we summarize the law interpreting the elements of potentially relevant obstruction statutes in an ordinary case. This discussion does not address the unique constitutional issues that arise in an inquiry into official acts by the President. Those issues are discussed in a later section of this report addressing constitutional defenses that the President's counsel have raised. See Volume 2, Section 3B Infra. Three basic elements are common to most of the relevant obstruction statutes. 1. An obstructive act. 2. A nexus between the obstructive act and an official proceeding. And 3. A corrupt intent. We describe those elements as they have been interpreted by the courts. We then discuss a more specific statute aimed at witness tampering and describe the requirements for attempted offenses and endeavors to obstruct justice. Obstructive act. Obstruction of justice law reaches all corrupt conduct capable of producing an effect that prevents justice from being duly administered, regardless of the means employed. An effort to influence a proceeding can qualify as an endeavor to obstruct justice, even if the effort was subtle or circuitous, and, however cleverly, or with whatever cloaking of purpose it was made. The verbs obstruct or impede are broad, and can refer to anything that blocks, makes difficult, or hinders. An improper motive can render an actor's conduct criminal, even when conduct would otherwise be lawful and within the actor's authority. Nexus to a pending or contemplated official proceeding. Obstruction of justice law generally requires a nexus, or connection, to an official proceeding. In Section 1503, the nexus must be to pending judicial or grand jury proceedings. In Section 1505, the nexus can include a connection to a pending federal agency proceeding or a congressional inquiry or investigation. Under both statutes, the government must demonstrate a relationship in time, causation, or logic between the obstructive act and the proceeding or inquiry to be obstructed. Section 1512C prohibits obstructive efforts aimed at official proceedings, including judicial or grand jury proceedings. For purposes of Section 1512, an official proceeding need not be pending or about to be instituted at the time of the offense. Although a proceeding need not already be in progress to trigger liability under Section 1512C, a nexus to a contemplated proceeding still must be shown. The nexus requirement narrows the scope of obstruction statutes to ensure that individuals have fair warning of what the law proscribes. The nexus showing has subjective and objective components. As an objective matter, a defendant must act in a manner that is likely to obstruct justice. Such as the statute excludes defendants who have an evil purpose, but use means that would only unnaturally and improbably be successful. The endeavor must have the natural and probable effect of interfering with the due administration of justice. As a subjective matter, the actor must have contemplated a particular foreseeable proceeding. A defendant need not directly impede the proceeding, Rather, a nexus exists if discretionary actions of a third person would be required to obstruct the judicial proceeding if it was foreseeable to the defendant that the third party would act on the defendant's communication in such a way as to obstruct the judicial proceeding. Corruptly. The word corruptly provides the intent element for obstruction of justice and means acting knowingly and dishonestly, or with an improper motive. The requisite showing is made when a person acted with the intent to obtain an improper advantage for himself or someone else inconsistent with official duty and the rights of others. Witness tampering. A more specific provision in Section 1512 prohibits tampering with a witness. To establish corrupt persuasion, it is sufficient that the defendant asked a potential witness to lie to investigators in contemplation of a likely federal investigation into his conduct. The persuasion need not be coercive, intimidating, or explicit. It is sufficient to urge, induce, ask, argue, give reasons, or coach or remind witnesses by planting misleading facts. Corrupt persuasion is shown where a defendant tells a potential witness a false story, as if the story were true, intending that the witness believe the story and testify to it. It also covers urging a witness to recall a fact that the witness did not know, even if the fact was actually true. Corrupt persuasion also can be shown in certain circumstances when a person with an improper motive urges a witness not to cooperate with law enforcement. When the charge is acting with the intent to hinder, delay, or prevent the communication of information to law enforcement under Section 1512b3, the nexus to a preceding inquiry articulated in Aguilar, that an individual have knowledge that his actions are likely to affect the judicial proceeding, does not apply because the obstructive act is aimed at the communication of information to investigators, not at impeding an official proceeding. Acting knowingly, corruptly, requires proof that the individual was conscious of wrongdoing. It is an affirmative defense that the conduct consisted solely of lawful conduct and that the defendant's sole intention was to encourage, induce, or cause the other person to testify truthfully. Attempts and endeavors. Section 1512c2 covers both substantive obstruction offenses and attempts to obstruct justice. Under general principles of attempt law, a person is guilty of an attempt when he has the intent to commit a substantive offense and takes an overt act that constitutes a substantial step towards that goal. The act must be substantial in that it was strongly corroborative of the defendant's criminal purpose. While mere abstract talk does not suffice, any concrete and specific acts that corroborate the defendant's intent can constitute a substantial step. Thus, soliciting an innocent agent to engage in conduct constituting an element of the crime may qualify as a substantial step. The Omnibus Clause of 18 U.S. Code Section 1503 prohibits an endeavor to obstruct justice, which sweeps more broadly than Section 1512's attempt provision. It is well established that an obstruction of justice offense is complete when one corruptly endeavors to obstruct or impede the due administration of justice. The prosecution need not prove that the due administration of justice was actually obstructed or impeded. B. Investigative and evidentiary considerations. After the appointment of the special counsel, this office obtained evidence about the following events relating to potential issues of obstruction of justice involving the President. A. The President's January 27, 2017 dinner with former FBI Director James Comey, in which the President reportedly asked for Comey's loyalty, one day after the White House had been briefed by the Department of Justice on contacts between former National Security Advisor Michael Flynn and the Russian ambassador. B. The President's February 14, 2017 meeting with Comey, in which the President reportedly asked Comey not to pursue an investigation of Flynn. C. The President's private requests to Comey to make public the fact that the President was not the subject of an FBI investigation and to lift what the President regarded as a cloud. D. The President's outreach to the Director of National Intelligence and the Directors of the National Security Agency and the Central Intelligence Agency about the FBI's Russia investigation. E. The President's stated rationales for terminating Comey on May 9, 2017, including statements that could reasonably be understood as acknowledging that the FBI's Russia investigation was a factor in Comey's termination. And F. The President's reported involvement in issuing a statement about the June 9, 2016 Trump Tower meeting between Russians and senior Trump campaign officials that said the meeting was about adoption and omitted that the Russians had offered to provide the Trump campaign with derogatory information about Hillary Clinton. Taking into account that information and our analysis of applicable statutory and constitutional principles, we determined that there was a sufficient factual and legal basis to further investigate potential obstruction of justice issues involving the President. Many of the core issues in an obstruction of justice investigation turn on an individual's actions and intent. We therefore requested that the White House provide us with documentary evidence in its possession on the relevant events. We also sought and obtained the White House's concurrence in our conducting interviews of White House personnel who had relevant information. And we interviewed other witnesses who had pertinent knowledge, obtained documents on a voluntary basis when possible, and used legal process where appropriate. These investigative steps allowed us to gather a substantial amount of evidence. We also sought a voluntary interview with the President. After more than a year of discussion, the President declined to be interviewed. 2 lines redacted, citing grand jury. During the course of our discussions, the President did agree to answer written questions on certain Russia-related topics, and he provided us with answers. He did not similarly agree to provide written answers to questions on obstruction topics or questions on events during the transition. Ultimately, while we believe that we had the authority and legal justification to issue a grand jury subpoena to obtain the President's testimony, we chose not to do so. We made that decision in view of the substantial delay that such an investigative step would likely produce at a late stage in our investigation. We also assessed that based on the significant body of evidence we had already obtained of the President's actions and his public and private statements describing or explaining those actions, we had sufficient evidence to understand relevant events and to make certain assessments without the President's testimony. The office's decision-making process on this issue is described in more detail in Appendix C Infra, in a note that precedes the President's written responses. In assessing the evidence we obtained, we relied on common principles that apply in any investigation. The issue of criminal intent is often inferred from circumstantial evidence. The principle that intent can be inferred from circumstantial evidence is a necessity in criminal cases, given the right of a subject to assert his privilege against compelled self-incrimination under the Fifth Amendment, and therefore decline to testify. Accordingly, determinations on intent are frequently reached without the opportunity to interview an investigatory subject. Obstruction of justice cases are consistent with this rule. Circumstantial evidence that illuminates intent may include a pattern of potentially obstructive acts. Credibility judgments may also be made based on objective facts and circumstantial evidence. Standard jury instructions highlight a variety of factors that are often relevant in assessing credibility. These include whether a witness had a reason not to tell the truth, whether the witness had a good memory, whether the witness had the opportunity to observe the events about which he testified, whether the witness's testimony was corroborated by other witnesses, and whether anything the witness said or wrote previously contradicts his testimony. In addition to those general factors, we took into account more specific factors in assessing the credibility of conflicting accounts of the facts. For example, contemporaneous written notes can provide strong corroborating evidence. Similarly, a witness's recitation of his account before he had any motive to fabricate also supports the witness's credibility. Finally, a witness's false description of an encounter can imply consciousness of wrongdoing. We applied those settled legal principles in evaluating the factual results of our investigation. Thank you for listening to this episode. This show operates on the value for value model. I make the show available, commercial-free, and you decide what it's worth. You can return the value in any way you choose. One way is by going to MuellerReportAudio.com and clicking on the donate button, or supporting with a recurring monthly donation at patreon.com/TimberlaneMedia. For your donation and to show my appreciation, I will recognize your name and donation amount in an upcoming episode. Or you can remain anonymous by going to glow.fm/insider. You can also value these episodes by sharing the show and telling your friends. Or you can follow on Twitter @GovUnfiltered or at Facebook.com/GovernmentUnfiltered. Thank you for helping make public documents like this one accessible through audio.